Welcome everybody to it's time to get your you know what together, all right? And we'll be discussing everything from estate planning to how to avoid probate administration and everything in between. Some housekeeping rules: keep your microphone on mute. If you have a question, please put it in the chat. And we won't mention your name just in case it's very private. And we'll have Q&A throughout the program and then at the end. So let me introduce to you Samantha Fitzgerald. Samantha is an attorney in Plantation, Florida, and her firm is 100% focused on estate planning and probate and trust administration. She's been practicing for over 20 years, and I know she looks marvelous. You would never know that. And she's a CPA and has an LLM in tax. Hello, Samantha.
Welcome, everybody. Thank you for joining us.
Thank you. And my name is Bianca Moreras, and I will be your host and moderator. I am a business development and career transition coach and consultant. I bring 37 years of experience to the table with a concentration in law firms and working with attorneys with the ability to help them to achieve anything they are looking for in their company. So without further ado, welcome everyone. I like to welcome back Danielle and Christine and Randy. We're happy to have you today and all those others that will be joining us. So today we're going to talk about administrating a trust. So Samantha, let me ask you, is a trustee the same as an executor?
No. So executor is a term we don't even use in Florida at all, although it's the most common term that people know. So sometimes we use it, just in our discussions because that's what people understand. But in Florida, the term is really personal representative. And the personal representative is the person that is appointed by the court to administer somebody's probate estate in the courts. A trustee is somebody who's appointed either in the document or by the court to administer assets in a trust. Oftentimes, they're the same person, the personal representative and the trustee, but they certainly don't have to be. So they can be completely different. Oftentimes, there is no probate administration, so there is no personal representative. There may only be a trustee. So these terms and these roles are oftentimes misunderstood, kind of commingled, very confusing for people to understand the different lanes that apply to somebody's assets when typically we're talking about when they pass away, although a trust could also be applicable while somebody is alive. So a trustee is another big difference. A trustee may be administering a trust and may be appointed while the trust creator, the grantor or the settlor, is alive, or they may be administering the trust post-death, whereas a personal representative or a true executor can only be appointed after somebody's deceased.
Wow, I didn't realize that. That is really great. And PR is not to be mistaken for Puerto Rican or Puerto Rico. So anyway, well, what does a trustee do, Samantha?
So let's start with what is a trust, because people have a really hard time kind of understanding this and wrapping their head around it. So a trust is similar to, let's say, a corporation. People understand what corporations are. It's a thing. It's this entity that can own assets, and somebody has to be in charge of running it. And that's effectively what a trustee is. A trustee is kind of like a hybrid between the personal representative or the executor and the president of a corporation. So they're this person that is appointed usually by the terms of the trust, sometimes by the court system. Person that's appointed to be in charge of the trust and to follow the terms of the trust and administer the trust. And that's what, administering a trust means, is to follow the terms of the trust carry out the settlor's wishes, which are set forth in the trust, as well as following the rules, of the statutes for the most part, Florida law rules. But they're basically just in charge. So they're in charge of making distributions to beneficiaries. They're in charge of investing the assets that are in the trust, managing the assets that are in the trust. If they're not liquid, you may have real estate in a trust. So they have a role that's similar to what people would think of as an executor, except their job may continue on and on and on and on for many years to come. Whereas with a probate administration, it's a finite period of time. You're appointed, you collect assets, you pay expenses, you make distributions to beneficiaries, and the probate administration closes, and the personal representative's job is done.
Oh, wow. Well, it sounds kind of complicated. Do trustees require an attorney for themselves?
So that is another big difference between a personal representative's job and the trustee's job. There's no requirement that a trustee retain counsel. It's highly, highly, highly recommended. So trustees get into all sorts of trouble, and I'm sure a lot of it is because they're not represented by counsel and they're not getting any legal advice, and they have no clue what they're supposed to be doing. A lot of trustees get into trouble innocently. They don't know that they're breaking the rules because they have no counsel. So if you are ever serving as a trustee, the first thing you should do is call a lawyer and get some legal advice. You may not need the attorney for the entire time that you're serving as trustee, but you certainly need legal counseling at the outset of taking over the position and understanding what responsibilities you have. Um, there's lots of different things that trustees need to do. Some of them have to happen right away. For instance, within the first 60 days of taking over an irrevocable trust, so that's typically when somebody dies, the trust becomes irrevocable. The successor trustee takes over because the settlor is now deceased. New trustee is there. What do they need to do? So within the first 60 days, they're supposed to be giving certain notices to the beneficiaries. Makes sense. Notify them that they are a beneficiary, that they're entitled to receive a copy of the trust, that they're entitled to annual accountings, give them the name and the address of the trustee. You may take that for granted, especially in family situations. A lot of times it's not done and it's overlooked, and it's okay if everybody's friendly parties. But imagine if you're not related parties or you're distantly related, and the beneficiary may not even know that the settlor passed away. So they're entitled to be notified that they're a beneficiary and of their other rights. And there's time frames for doing things.
Wow, it's starting to sound complicated. Do I want to be a trustee?
Probably not.
It sounds really complicated. Oh my gosh.
It is
You
a
know,
big responsibility. And if you're ever asked to be a trustee, you definitely need to think twice about it. Just don't automatically accept the position, because you may be stuck in it once you're serving. It is really a big responsibility, and trustees get sued all the time. Sometimes you get sued because you made a distribution. Sometimes you get sued because you didn't make a distribution. Um, Lots of times beneficiaries are happy, one way or the other. So it is a big responsibility. And if you are sued, there are rules as to, obviously you have to hire a lawyer to defend yourself. Well, who pays the lawyer? So it really depends. There's rules surrounding the answer to that. Sometimes the trust assets can be used to pay your attorney fees, and sometimes they can't. So that really stinks if you're serving as a trustee and you feel you've done everything right, but you have a disgruntled beneficiary and they sue you, and now you have to come out of your own pocket to pay for your legal counsel. The flip side of that is, you have a trustee that really did do something wrong, and you don't want them furthering the bad acts by depleting the assets of the trust to defend themselves from the wrong that they did. So it can be tricky. So certainly, you have to be careful and really think twice about doing it. And I highly recommend anybody who does serve as a trustee to be compensated for their time. All trustees are entitled to be compensated unless the trust says otherwise.
Yeah, that was going to be my next question. Like, it sounds so like so much work, like, do you get paid? I mean,
Yeah, it is a lot of work. Even if you're not getting sued and even if everybody's happy, it's a lot of work. If anybody here has ever served as an executor, personal representative, or trustee, it's a lot of work. Even a simple, an estate that's organized, well organized and well documented is still a lot of work. It's just the nature of the beast. So you definitely should at least consider being compensated. Sometimes maybe it doesn't make sense if you're a close family member and that fee is going to come out of your share of the estate. Then do you want to be compensated? Because technically it's taxable income. Whether you report it or not, it's up to you, but it is considered taxable income. So it would be silly to take a devise of your beneficial interest, which is not taxable usually, and turn it into something that is taxable. So that doesn't really make sense. But it does come off the top. So it is a way to get you extra and compensate you for the time that you've put into it. If you're not a beneficiary, definitely get paid for your time. Why would you want to do it otherwise? And you're subjecting yourself to liability. You're putting yourself at risk and not getting compensated for it. Why would you want to do that? So definitely at least think twice about it. I never allow my clients to draft a trust saying no compensation. I have lots of people who try to do that. Oh, well, I don't want, Bobby Sue getting compensated. They should just do this. I wouldn't even allow them to do it. Everybody should have the option of being paid for their time.
well, that's good to know. Not that I want it as a job or anything. So when do the responsibilities actually start for a trustee?
So they start immediately upon accepting the position. So that's kind of an important point, that just because somebody has named you in a trust document doesn't mean you have any obligation to serve as trustee. You have to actually accept the position. So you're up at bat when the prior trustee, whether that be the settlor or somebody else, when they become incapacitated, resign, die, or otherwise cease as serving as trustee. It goes down to the next person. So then you have to accept the position. And once you accept, you're it. So your responsibilities start immediately. You are not liable for any acts of prior trustees. But from that point forward, when you accept the position going forward, you're on. So at that point, if that 60-day notice applies, you're required to send that out to the beneficiaries. Another big responsibility of trustees is filing tax returns and providing an annual accounting to the beneficiaries. That's where I see a lot of beneficiaries get into trouble, is failing to provide that annual accounting. It's really common. We'll get a call from a beneficiary. Yeah, I'm a beneficiary of a trust and I don't know what's going on. How long has the trust been in existence? 5 years. Well, have you received anything? No. Maybe they're getting distributions, maybe they're not getting distributions, but they're not getting annual accountings to tell them what's come into the trust, what's gone out of the trust, who's getting paid, what the trustee's compensation is, if anything, what the lawyers are getting paid, if anything. So that's a biggie where trustees fail. But your responsibilities start right away.
All right, so they start right away, but like, what if I don't want to be a trustee anymore? What do I do?
So first thing you always do when you have a question about a trust is you look to the actual trust agreement to see what it says. And there's oftentimes some sort of procedure for resigning. Hopefully there is a a person named as the next successor trustee or a method of appointing the next successor trustee. And hopefully that person accepts the position, because you can't resign until the position is filled. You can't resign leaving no trustee of the trust. So if you accept the position, you need to know that you're in it until you can resign. If there is no method of appointing the next successor, the beneficiaries can appoint somebody. Hopefully, the beneficiaries are capable of doing that, that they're not incapacitated themselves, they're not minors. You may have to petition the court if there's no method of appointing that next successor trustee. And until you're in front of the judge and somebody accepts the position, you're probably on the hook and need to stay there and continue your fiduciary responsibilities of administering that trust prudently. Trustee has all sorts of fiduciary obligations and responsibilities.
Oh boy. Well, I'm thinking like, it sounds like I can get in trouble. Like, what are some of the most common things that get a trustee in trouble?
So the accounting, for one, that's probably the biggest that I see, at least. Or trustees self-dealing, so taking things for themselves that they shouldn't be taking. As a simple example, let's say a trust owns a piece of property, and innocently the trustee says, well, nobody wants it, we're going to sell the property, I would like to buy this property, and I'm going to buy it for fair market value. You've just breached your fiduciary obligation, fiduciary duties, because you can't do that. Now, you can with everybody's consent or the court's consent, but you can't just do it, because you have, a duty, no self-dealing, duty of impartiality, a duty of loyalty. There's lots of duties that those trustees have to the beneficiaries. So that's a good example of how a very innocent situation goes wrong. But sometimes they do things, bad things. They steal. They pay people that shouldn't be paid. They make distributions that shouldn't be paid. They could be kind of strong armed into making a distribution to a beneficiary because the beneficiary is asking for it, but the beneficiary really shouldn't be getting it because maybe they have creditor problems, or they have a drug problem, and then the trust is depleted, and then the beneficiary comes back and sues the trustee. You knew you shouldn't have. That's why my mom or dad set up this trust. You shouldn't have made distributions to me. So there's some obvious ways that trustees get into trouble because they did something wrong, but then there's lots of ways where they get into trouble for in more of an innocent way, where they don't realize. And that's where the having counsel really becomes very important, because if they had somebody guiding them as to what to do with those distributions, they probably wouldn't get quite in as much trouble. Other duties that trustees have, a duty to distribute income if the trust is silent on what happens to income. So maybe they don't know they're supposed to. They have an obligation to distribute income if the trust is silent, so they can get in trouble later on. If they're supposed to distribute income and that income is then reportable by the beneficiary on their tax returns, and they don't report it because they didn't even know about it and they didn't receive it, they could have IRS troubles. Maybe they owe interest and penalties at some point. They have a duty to ascertain marketable title or to pursue and defend claims. So, maybe there's something where they say, well, the trust may have a claim against so-and-so, but I don't want to get into all that. I don't want to do it. Well, guess what? You have a duty to look into that. Maybe it's not feasible and it's not worth it financially to do it, and that's the ultimate decision, but you have a duty to investigate whether the claim is valid. You have a duty to defend against claims, and then a duty to ascertain whether property that may be owned by the trust has good title. if there's any question about it. So being a trustee comes with tremendous responsibility.
So I was going to ask you a question on what a trustee does first, but I do have a question in the box and it might be related. So the question is, what other responsibilities of the trustees, such as filing tax returns and annual accounting, it starts right away. What does starts right away mean upon the death and upon the death of the person's trust? Is that what it means?
Usually we're talking about the date of death, the date of death forward.
So right away is date of death forward.
Yeah. So like the annual accounting will go from the date of death 12 months later. The tax return gets filed. Usually it's on a calendar year, although there is a way to file a tax return on a fiscal year for trust, but the default is a calendar year. So if the settlor died February 15th of 2021, you're filing a tax return for the year 2021 in 2022, of course. But the trustee's responsibilities are going to start as the date of death. I mean, I said before, when you accept the position, but usually that's happening very quickly after the date of death because you're trying to administer the trust and collect the assets and find out what's going on. And those dates are usually very close together.
I have one other question. If a husband and wife are in a trust and one dies, is it automatic that that person is now the trustee of the trust, or only until both die?
Well, you have to look to see what the trust says.
Okay. All right.
In terms of the trust will control.
Everything that's written will be so, right?
That's what we hope, at least. That's the plan.
That's the plan, right? Everything that's written will be so. Oh my God. Okay. And so if someone is asked to be a trustee of a special needs trust, should they take on that responsibility?
So that's an even bigger responsibility because special needs trusts, which are also known as supplemental needs trusts, are a very special form of trust. They're created for somebody that is disabled, typically, and usually that disabled person is receiving some sort of need-based government benefits, Medicaid, SSI, something like that. And the trust is established because the assets in this type of trust are not considered a resource to sorry, my phone's ringing. I hope you can't hear that. It's not considered a resource to the disabled person, which is great because they can continue receiving all their benefits and they have this lump sum of money sitting in this trust. But there's lots of rules surrounding that. You can only use the money from the special needs trust for certain expenses. And it's way too complicated to, jump into in this Zoominar. But there's lots of rules, and it's hard enough administering a regular trust. Administering a special needs trust really requires special information. So for sure, you want counsel, no matter what. You absolutely want counsel if you take on the role as a trustee of a special needs trust. But there are trust companies that specialize in this, and under most circumstances, it's probably better to allow them to do it because they're going to ensure that the beneficiary doesn't lose their benefits, which could be detrimental. Something like Medicaid, if they lose that and they have a severe medical problem, that's going to be a disaster. So you definitely don't want to run afoul of those rules. They're extremely complex, super duper complex. I mean, it's a mixture of federal and state laws, really, really complex, easy to run afoul of them. Oftentimes you have situations with children and then the parents who are not the trustees. So you have this, for instance, as an example, the special needs trust can pay for vacations for the beneficiary. That's okay. It's typically there to pay for extras, not the basic needs of the person, but for extras. So they pay for the child, to go to Disney World. Well, does the whole family go to Disney World on the dime of the special needs trust? There's rules surrounding that. So if you have just a regular layperson serving as trustee of that, they're not really going to understand what they can do and what they can't do, and it's going to be definitely amount to a huge problem.
Oh my gosh, that does sound complicated. So, I hope no one is in that situation as far as that goes. And that was all great information. I want to open it up to the floor to see if anybody has any concerns, or even out of the context of trust, if you have any questions, that burning desire or something like that. Anyone? Well, my thought process is everyone needs to, of course, I'm sorry?
I think Danielle's thinking.
Oh, Danielle's thinking. Okay, you wrote down so many things. Hi, Pam. We didn't get to say hello to you. Good to have you back. Good to see you. So as you know, those of you on the call, Samantha's very happy to entertain any question that you have after the program. If you would like to talk to her personally, Samantha can be found on, let me just type your number in here, or unless you would like to put it into the chat, Samantha, just put your phone number for those that are new to the program, that they have it. That will be helpful. And if anybody would like to put their information in as well, in case you make a connection here. So when we have a few minutes left, I always like to let people introduce themselves and just say, real quick, 1 minute about themselves, and anything that they want to say to Samantha. So I'm going to start with you, Danielle. Make sure you take yourself off mute, everybody.
There we go. All right. Thank you. My name's Danielle. South Floridian since 1968. I've been in real estate for now over 3 decades, very happily so. I've known Samantha for some years. She drafted the trust for 2 very, very dear family friends, and they were drawn incredibly well because one of them passed away shortly after, within a couple of years, and there were no issues whatsoever. She's always available, always gives thorough answers. So Samantha, thank you so much, because these Zoominars I go back on my notes and I read back on them, and I'll just tell anybody who will listen that they should join. Very valuable. So thank you for that.
Welcome.
Awesome.
Love that you take all those notes. That's great. You're our best student.
Yeah, she's a good student. How about you, Bill? You're new to the group.
Well, basically, I show people how to increase their cash flow. Sometimes they have a lot of student debt. Usually they have mortgage debt, they have credit card debt. So I show them how they can use their own money that currently they're using inefficiently, and they don't take any money out of their pocket. We just redirect it to a more efficient method. We call it setting up your own bank. So all that money that you're giving to credit card companies and banks, you can recapture. And I know Danielle, she's in the real estate business, so I'll just say, I'm sure she's had people that have wanted to buy a property, but they couldn't get a pre-qual letter. And usually what happens, they walk away, never to be sold again. Those people, I can help them. Not only will they buy a property from you, they probably have friends that will now be able to buy properties. So pretty much that's what I do.
That's great. So why don't you put your information in the chat, Bill, just in case any of these young ladies like to reach out. And Pam, tell us a little bit about you. And if you'd like to give a testimony for Samantha.
Samantha did my trust, and I'm sure she remembers it well. It was a very long and tedious experience. And I guess I kind of have a question. Samantha, as you know, I probably should do a corporate trust, but I am not a trusting soul. So I really have a problem giving that ability to somebody that I don't know. How do I really trust a corporate person to handle a trust? I'd have to give them a copy of it now, and you have my copy, Samantha.
You don't
How
have
do I-
now, because they don't take over as trustee until later. They like a copy of it now, but you don't have to because they're not really accepting the role until something happens to you. And corporate trustees, look, it's their business to be a corporate trustee. So they follow the rules. They follow the rules. Sometimes they follow them too closely and they can be a real pain in the butt. But they do the job, so they're good when you don't have somebody else to serve in that role. But sometimes they cause more trouble than they save. Depends, just really depends on the circumstances.
So even if I'm the primary trustee now and I have two people as a alternate, they can't do anything until I'm no longer here. Because I'm thinking that they still have the ability to do something.
No, nobody
I'm
says
alive.
you can do anything until you're dead or incapacitated.
That's it. Okay.
That's
Okay.
good information.
Yeah, for me it is. I can breathe.
So do you have a business, I assume, since you're saying
No,
you're corporate? Oh,
I'm retired.
all
I'm not
right.
doing
Yay
anything.
for retired. Yay.
Hey.
Danielle and I were just talking about, putting some time aside to really work on our trust that were established 15 years ago. In 15 years, I'm now, I now have 6 grandchildren. Lots of things happen. And I had initially designated some beneficiaries, which I probably would change. And I just need to do a whole lot of updating to this trust. And Samantha, one day I'll get there.
Like we always say, Christine, it's time to get your what together, because especially with what happened in 2020,
Yeah.
we know how unpredictable the world is.
Yeah, planes can
So
crash on your car as you're driving.
yeah, and there's no time like today, and we always have to make time. We don't think it's so important, but it is very important. And mazel tov and congratulations on all the grandchildren.
Thank you.
Definitely you don't want anybody to be left out,
Yeah.
because that will create war. As you
I know, we realize the
family.
importance of trust and all that. I guess I do have one question for Samantha. I know we're running short on time, but
Problem.
I designated my daughter as my trustee. She's very responsible and typically really good with finances and understands my wishes. Was that a smart thing to do?
Depending on longer conversation.
Yeah.
Okay.
So why don't you give a buzz to Samantha?
I will.
I'll be
I
happy
will.
to talk to you. So hopefully, Christine, by the next meeting, I'm going to hear that you made an appointment, and we love that you're a fan.
Okay,
So
great.
I want to again tell you, Samantha's gift to you is, that 30-minute free consultation, and, the appointment is always available. But on behalf of Samantha Fitzgerald and myself, I want to say thank you for coming. Last words, Samantha?
Also just want to say thank you everybody for coming. This was fun. I'm glad you had questions and took notes. So hopefully you will make it next month. The third Friday of every month, we do this for a half an hour, different topics every month.
So April 16th, mark your calendar, and we'll see you
Okay.
again.
Have a
And
Thank
thank you,
you.
Bill, for coming. Bill's information's in the chat if anybody needs it. And I thank you very much.
Awesome. Thanks a lot. Have a great weekend.
You
You
too.
too.
Thank you.
Bye-bye.